Okay, thank you, Gustavo. Okay, so I see the live stream has begun. Can we start, Gustavo?
Yes, we're good to go.
Sorry, I didn't hear you.
Yes, we're good to go now.
Okay, so welcome to the first open lecture presented by the Center of Asian Legal Studies of the University of São Paulo. Thank you all for coming and joining us. And at first, I'd like to say this event was only possible thanks to the joint effort of our coordinations, but also due to the help of some of our participants, such as Gustavo Schneider, who is helping us with the technical aspects of today's meeting. So at first, I'd like to present to you how the discussions today will be conducted so we can proceed to the presentations. So this is a very relevant theme at present. Recently, we have the signing of an agreement between the mining companies and the state of Minas Gerais in Brazil. And also, we are currently facing some issues with salt mining in one of Brazil's capital cities. But it's also relevant in a global perspective. So we may see some issues that may emerge with COVID-19. And this lecture is very well tuned to the proposal that CELA has in this semester, which is to discuss how we recur to legal institutions in times of crisis, which I believe is something that should ever be noted, so we can be better prepared for times such as those. So I'd like to then present the lecturers today. So we have today here Professor Eric Feldman. Eric Feldman is a lecturer at the Heimel Chair in International Law, and he's also a professor of medical ethics and health policy at the University of Pennsylvania. Besides, he's the Deputy Dean for International Programs. Professor Eric Feldman has earned his bachelor's degree in Vassar College in 1982, and also his JD at the University of California, Berkeley in 1989. Then he earned his Ph.D. in jurisprudence and social policy, also at the University of California, Berkeley at 1994. So some of his topics of interest usually include Japanese law, public policy, also the relation between law and healthcare, health law. And he also wrote 2 very relevant articles concerning the compensation of victims due to the Fukushima disaster, and how the Japanese government and the Japanese corporations have dealt with this very sad event. Then Professor Carlos Portugal Gouvêa is professor of corporate law at the Faculty of Law of the University of São Paulo. He earned his Masters of Law in Harvard University at 2004, and his PhD in also law in Harvard University 2008. He has been teaching at the University of São Paulo since 2011, and some of his main topics of interest are capital market, corporate law, corporate governance, and the relationship between artificial intelligence and law. So the lecture will follow. So we will follow this schedule. Each of the lecturers will present for around 20 minutes their own points of view concerning the Carlos will present the Brumadinho and Mariana disaster and the responses found by the state government and also our legal system. And then Eric Feldman will do the same concerning the Fukushima disaster. Each of them has their own specific points. And after this, there will be a short discussion between the lecturers, and then we will open to questions at the end of the lectures. So thank you for joining us, Professor Feldman. Also, thank you for joining us, Professor Carlos. And Professor Carlos, you may begin your presentation.
Thank you. Thank you, Caio. Would like first to congratulate all the coordination of CELA for putting the program together and organizing the presentation today. I think we will have a wonderful new semester. And also would like to thank Professor Eric Feldman again for accepting our invitation. It's always wonderful to have the opportunity to discuss different topics with him. Last time, I believe I was in Philadelphia with him. We did this kind of a mixed class with people in Brazil and people at your class of Japanese law. Unfortunately, it's not possible to do the same again, but I think we will have a wonderful discussion today. Your studies regarding the Fukushima disaster, I think, have several aspects that will help us figure out better a system to deal with disasters in Brazil. So I'll try to be quick so that we can enjoy your presentation. So the Brumadinho disaster brings me some horrible feelings, because I remember the day that the disaster occurred, and I was pretty shocked about it, exactly because we had just a few years before another horrible disaster in Mariana, also with a dam in a mining company that collapsed. A dam that was owned by a joint venture company in which Vale also had a 50% stake. So I was pretty shocked, and in this period, nothing was really done to prevent another disaster like that. And the Brumadinho disaster was pretty shocking, not only because of the scenes that we watched on TV, but also at a certain level because of the degree of stupidity involved, because we had the managing buildings of Vale situated right in front of the dam. And those, in a sense, you would think that, those corporations, they would think about themselves. You have the managers of the company were in those buildings. So how come they put themselves in harm's way in a situation like that? So when something like that happens, the solution is it can't be found only on corporate governance issues. You cannot only think about making managers responsible, because at a certain point it was a massive failure. So in a sense, we need to think of long-term solutions to prevent that, to create incentives for people to really work towards avoiding these kind of disasters. I think differently from Fukushima, I don't know the case so well in the technical respect. I believe that the Mariana disaster was pretty much avoidable to a very high degree. Not avoidable in the sense that dam ruptures are avoidable. They are not. They happen all around the world in a statistical level, but usually those dams are placed on certain locations where the consequences for the rest of the society will not be so dramatic as they were in the case of Mariana and in the case of Brumadinho. So we really need to put the incentives in place to prevent that from happening. And how we deal with past disasters can teach us a lot about how, if we have those incentives in place or not. So one of the issues that we have to worry about is full compensation for those that suffered the damage. Because if we don't have full compensation, we will end up having what in the theory of corporate ethics is regarded as compensatory deficit. So if systematically you have damages caused by corporations in society, and those damages are not fully compensated, in practice, what you are creating is an incentive for practices that put various levels of society at danger. So full compensation is very important. And from the perspective of the victims, fast compensation is really important. So when I saw the disaster, I really thought, we need to put a system in place that will eventually result in a fast payment. And when I thought about it, I was thinking of what happened in Mariana. So what happened in Mariana, in a sense, was a chaos. So the compensations were paid very slowly. They took quite a while to make those payments. And in a second, I will discuss that. But in the case of Brumadinho, Vale itself estimates that about 105,000 individuals suffered damages. And those damages were related to both potential civil cases and potential labor cases. So it's a very substantial number of people that had to be paid. And of course, Brazil is very well known for having a very slow judicial system. So in a sense, I believe that the company itself, like Vale, would have an incentive to pay those people quickly, because in a sense, they also would like to get it behind them and be able to eventually improve their image before investors in general, and also their customers around the world that eventually would, at a certain point, possibly because of ESG pressures, for example, be forced to avoid purchasing products from Vale because of their poor environmental practices and the disasters in which they were involved. And in a sense, Vale was already involved in what was going on with regards to Mariana. So in a sense, they knew it, and they probably would have the incentive to, try to do it better a second time. So what I suggested at first would be exactly the idea of implementing a dispute system design adequate to this particular disaster. So in Brazil, we had just had a new civil procedure code that incentivized mediation alternatives. And in a sense, that would be the best alternative in this particular case, because we could then prevent those cases from going to the courts in general. What eventually could lead to indemnifications for the victims for larger amounts, but certainly they would take much longer. And in a sense, from the perspective of victims in general, if it takes too long, it's not worth it anymore, because the collateral damages, let's say, of eventually going through a situation of extreme need, eventually hunger, eventually not being able to keep your kids at school, a total economic collapse that might affect those victims, might generate long-lasting damages on older people that might have their health affected, working people that might have their mental health affected, and children that might have their nutrition and their education affected for life. So in a sense, paying quickly, even if it's a lower amount, it's better than waiting. And the problems that we have with Mariana, in a sense, were, in my view, the result of our lack of experience of how to deal with disasters like that. In Brazil, we had actually Mariana and Brumadinho were probably our largest, most relevant environmental disasters. So in a sense, we had a pretty good, pretty effective environmental rights legislation up until that point. But that legislation never discussed or included any real reference on how to deal with large litigations regarding massive disasters like that. And besides that, in Brazil, we also have a very cumbersome case law regarding the equivalent to class actions in Brazil, the ação civil pública. We haven't had sufficient consolidation in the judiciary of certain very important aspects of this legislation, specifically if this kind of lawsuit is adequate to providing indemnification directly to individuals or not, or if they are adequate only to providing indemnification to the state for collective damages. So in a sense, from a legal standpoint, we were not fully prepared to deal with this kind of disaster. But also the practical solution that resulted from the Mariana disaster in courts, and from what I understand also based on the proposition from the companies themselves, was also a disaster. So what they proposed was the development of the creation of a foundation, which on and by itself would be the last thing that I would recommend to manage that large sum of amount. But apparently the Ministério Público, the state prosecutor's office, required that. And the result ended up being a disaster, because this foundation that was created, the Renova Foundation, was not able to make the payments as quickly as it would be expected. In that regard, I believe that one of the problems that led to this was the governance of the foundation. I would like to show you the page of the foundation itself. And even those of you who were not my students of corporate governance will probably understand why I think it's a disaster. So I believe you guys are seeing that this is the governance structure of the foundation, and it's completely insane. You have this external committee, this interfederative committee If you look at it, it's just insane. You have like members from the Ministério Público, from the federal government, the state of Minas Gerais, the state of Espírito Santo. Then you have separated technical chambers, and inside the foundation you have like a very burdensome organization. So in a sense, you know, it has so many parties involved in that: the federal government, and in the federal government, the Federal Prosecutor's Office. You have members of the federal executive branch, and then you have a consultative board, and then you have the officers, and you have several other bodies all around it that make it just impossible for this, you know, organization to take any decisions. You know, something that I joke when I talk about it, it's just like you never make a organizational chart that is round. You know, it's probably gonna make you just, you know, walk in circles, and that's not what you want. In those cases, you want to be very quick, and you want to be able to disperse those payments also very, very quickly. So in a sense, I believe that Vale learned from that experience. I think they understand also that it was not a good alternative. You need to have an executive organization that can, you know, provide for the payments quite quickly. And also, this system was so slow that it actually invited several other sources of litigation. So one famous situation was actually a class action that was brought against BHP before the courts of England. And in this class action that had, I don't remember the numbers exactly, but more than 200 plaintiffs, 200,000 plaintiffs. One of the arguments and one of the grounds that had to be covered to allow the case to be heard before British courts was that the Brazilian legal system was not working properly. And in a sense, that could be the case. You know, if the case was heard, it ended up being dismissed on procedural grounds. So we didn't have to go through this kind of investigation. But in a sense, I believe that if the hearings continued, probably it would be a bit shameful for the Brazilian legal system to be exposed in such a way and to demonstrate the failures of our legal system in the process of providing those payments more quickly. And what happened here was that even the governmental agencies started to fight among themselves. I won't go into details, but we had mainly a clash between the state prosecutor's office and the federal prosecutor's office. So this demonstrated for me a classic situation of a lack of institutional experience to deal with those kind of disasters. So in my understanding, what Vale learned was that it would need to take the situation in their hands, and they would, in a sense, not wait to have a deal with the federal prosecutor's office or the state prosecutor's office. The best alternative would be to go quickly to a system of mediation that would eventually allow them to pay as many individuals as possible. And in a sense, I think they did that. They set up a dispute system, dispute resolution system that has been working well. And Caio already mentioned that a few months ago, on February 4th, they signed it also in a mediation process, what I believe was also a good step forward, an agreement with all those institutions. So in a sense, I believe that we had, if we compare the two processes, we had a clear institutional development in this process. And the changes on the Brazilian Civil Procedure Code, I believe, were important in that process. So in Section 3 of our Civil Procedure Code, we adopted what might be called a multi-door court system. So the understanding that sometimes to dispense justice, the traditional court system is not sufficient. You need to have multiple systems, sometimes operating together, what eventually might be understood as a conflictual process. But actually, though, that diversity is actually what will eventually serve justice better. So if you have a mediation process and a dispute resolution process, eventually those will serve to make those payments that are more important to people to avoid secondary damages to them derived from not having money for basic needs. And eventually, larger organizations will choose to go for traditional litigation, or eventually the Ministério Público will opt, instead of making an agreement, what ended up happening, they will opt to start a class action. But the fact that you will have several methods doesn't mean that you will not have justice. You know, it might be that some of those methods are better for certain groups of people, for certain individuals. So that alternative certainly will help. So in a sense, I believe that when this process ends, I think it would be interesting. And for those of you, our students that will start your research process for your thesis, that might be interesting to investigate exactly that, the differences in the methodologies, so that we can consolidate this institutional knowledge and improve our response to future crises like that. And as I mentioned, a good legal system to respond to those tragedies helps in not only in the disbursement of justice and in the compensation of the victims, but it also prevents future disasters by reducing this compensatory deficit. But of course, we need to look beyond that. We need to think of a system that creates incentives for companies to improve their not only compliance, but also their technical capacity to prevent this kind of damages. And in this aspect, I think that the insurance system can be very helpful. And one possible alternative that I wrote in a piece on a Brazilian newspaper just a few days after the disaster that I thought could be helpful would be to create a system, particularly in the region in Minas Gerais, where you have several of those dams for mining rejects. One alternative would be to have a mandatory insurance system. So the companies would be required to pay insurance, having as beneficiaries the potential victims, and not only victims as individuals, but also companies and churches and, you know, organizations of the government that might be affected, the environment in general. So it would require those companies actually to spend a quite substantial amount, if it was done right, on insurance, because the policies would be very substantial. The amounts covered by the policies would be eventually very, very substantial. And the companies that would be willing to set up those insurance systems, I believe they would invest on two things. First, they would probably, and most hopefully, they would improve oversight over the companies and the dams. So they would engage independent technical individuals that would help in this process and help the companies themselves to, think twice about the risks that they were taking. Sometimes you just need another pair of eyes to, for example, in the case of Brumadinho, to show to the company, take your management team away from, the front of the dam. It can collapse. And also, the insurance companies could invest on mechanisms to provide those dispute resolution systems afterwards, improve institutionally mechanisms for dispute resolution. But in a sense, also mandatory insurance would be required, because Brazil is a country, as most underdeveloped countries, that is also underdeveloped in its financial system and in the insurance system as well. So I looked at some data from the OECD today, and I noticed that when the Fukushima disaster happened in 2011, Brazil had insurance market measured by the number of premiums paid in the year that were equivalent to only 2.40% of its GDP. And on the same year, Japan had a percentage that was on the average of the OECD countries, the rich countries, of 8.83%. So almost 3 times more. Now, in 2019, when the Brumadinho disaster happened, this number had been reduced a little bit. Brazil improved, and it had 3.45% of its GDP on the insurance market, and Japan had 7.32%. And this creates a situation in which we can almost presume that most of the people that suffered damages from those disasters had no insurance. And of course, insurance is unevenly distributed in society. So usually the wealthiest people would have insurance, those that need the least, and the poorest people would not have insurance. And what is the advantage of insurance in general is that, especially when you have like people that are not sophisticated or are not rich enough to engage, private lawyers, what the insurance system does is that it makes the payment for the victims, and it takes the legal standing of the victim in claims against the companies that caused the damage. So what you get here is that you create almost automatically a dispute resolution system, a collective dispute resolution system, because you will then have a negotiation between basically 2 insurance companies. You have the insurance company of the company itself and the insurance company of the beneficiaries. And in my experience, insurance companies are pretty quick in solving those problems. They have a lot of experience. They have data that goes way beyond usually one single jurisdiction, and they are very quick on solving those issues. And in a sense, that's what I understand should happen. So my hypothesis that I didn't actually test is that in the case of Japan would fare better in dealing with disasters like Fukushima, because it's a highly insured society, and this in a sense would help. And in our case, we would have a lot of difficulty, because you would have in one side the company and a large and sophisticated insurance company, and in the other side a very large group of not very sophisticated from a legal standpoint individuals that would depart already from a very substantial disadvantage in this process. So I hope I didn't, I believe I took a little bit more than I should, but sorry about that. But looking forward to hear from Eric also what we can learn from the Japanese experience.
Yeah. Thanks a lot, Professor Carlos. It was an awesome presentation, and I was really interested in this insight concerning the insurance. I also believe it would have been a very helpful at those times of Brumadinho and Mariana. Professor Feldman, you may begin also your presentation. Thank you.
Okay, well, thank you very much. Thank you, Gustavo, for making all of these complex technical arrangements actually work. And Caio, thank you to you for all of your emails and organizational skills and making sure, despite my moving around different time zones, that we still are all here at the same time. And to Carlos and all of you, I really appreciate being part of your CELA community. I hope someday I can actually meet all of you in person and visit, but it's really an honor to be involved with your law school and be involved with the students coming through the program. So I really appreciate this ability to return to you virtually during this incredibly unusual year. I have the rock garden of a very famous Zen temple in Kyoto behind me, in part because I spent a good deal of the pandemic in Japan. And so I'm hoping perhaps the next time we meet by Zoom, we'll be speaking about another disaster that's unfolded globally, the COVID-19 disaster, and the different ways in which our societies have been challenged by that. Disasters themselves are really tricky things to talk about, in part because it's never clear that we have a shared, and by we, I mean those of us globally thinking about events that cause harm to human beings, that we have a shared definition of what a disaster is. For hundreds, perhaps thousands of years, humankind thought of disasters as things that were created by God, by divinities, by things well beyond any force we could understand. That definition gave way to a view that disasters were some consequence of forces in the natural world, tidal waves, hurricanes, fires. Now we're much more focused on disasters as a consequence of human action and human activity, corporate responsibility, et cetera. But we, I think, before we really dig into what counts as appropriate compensation for these sorts of harms, need to better understand what the harms are we're worrying about. Because of course, in both of our societies, we deal with people who suffer harms every day from all sorts of things, auto accidents, products, pharmaceuticals, et cetera. And we generally think of those as accidents, not disasters, as deserving of compensation only if our tort systems find a way of allocating fault for them. But today we're talking about a different sort of event that causes a lot of human harm. I have a PowerPoint that, I mean, part of me is just tempted to say Carlos's presentation was so full of rich ideas and thoughts, and I'd love just to spend 20 minutes commenting and engaging in a conversation. But I promised you Fukushima, and I put together a fairly long and detailed PowerPoint. So I'm going to try to keep my eyes on the clock and make sure we have some time when I'm done. And I'm going to share my screen so we can go through it. So where is, so the shared screen function is apparently not well, let me see, but somehow or other this, I have a PowerPoint on my computer, but it's not coming up. I'm assuming you cannot see that, correct?
No, not right now.
No,
Okay,
Not
desktop,
yet.
whiteboard. So which one of you are adept? Because when I'm doing shared screen now, it's giving me basic, advanced, and files, and it's not allowing my PowerPoint to show up.
Professor,
It's asking me to open system preferences. I think there's a security issue.
Eric, do you want to send it to me by email and then I can share my screen eventually? I don't know.
Sure, because this is
Technology, I always try to go around it. I have a problem because, you know.
Deck.
It's not too heavy, maybe.
Oh, it may be. Let's see. Okay, I just sent it to you. But there's no reason why I shouldn't be allowed to share my screen.
Yeah. Yeah. Mine worked well.
Oh. Yeah, it's telling me I have to leave the Zoom meeting in order to make this work.
Oh, gosh.
And I just got something that was asking me to close the meeting for all of us, which I did not do. Did you receive the email, Carlos?
Not yet. Oh, yeah, I did. I
You
got
did.
it.
So the trick is you're going to be having to forward it constantly because I have like each sentence is on a different click.
No problem. Oh, wow. Shit. Let me. Just improve the view here. What do you think, Caio? Is it good?
Okay, so if you can see that, then we will, I guess we will forge forward.
Yes, we can see.
Okay, so I'm sorry to lose some time. I'll speak even more quickly. And Carlos, you can start to click forward, right? The general issue here is really what society should do about compensating those who are victims of huge disasters. I'm assuming that at least some of you were relatively young 10 years ago and may not really be very aware of exactly what happened on 3/11 as opposed to 9/11, 2001 in Japan. There was a massive earthquake, magnitude 9. There was a huge tsunami, 40 meters high. 20,000 people were killed. 1 million homes were destroyed or damaged. And a nuclear power plant exploded. And what I have in the next screen is just a couple of clips. And Carlos, maybe you can click on the first one, and then it's something like 4 or 5 minutes. So I don't want to watch the whole thing. I just want people to appreciate really what this disaster was about.
I think I have to. I will change my sharing here. 1 second.
So yeah, you can hit play on that, and then you can fast forward a bit because you'll see this looks like a kind of a normal day along the coast. You can see that there's a wall, a barrier wall there. You can stop there. And then you can hear people shouting as they see this wall of water coming in. And then if you fast forward a little more, you'll see it breach the wall. Right, they're seeing a car driving, and watch the boat here. So all of a sudden the water's over the wall, and life is indelibly changed there, right? The boats are washed over, the automobiles are washed over, the houses are washed away, and people had inadequate warning as to when to move. Obviously, the barrier wall there was way too low, and the water continued kilometer after kilometer inland, destroying really everything that it could reach. So what you see from this initially is the massive destruction that resulted from two things: the earthquake, which leveled some buildings, not in this town, and then the tsunami that followed. The next video, if it's not too much of a hassle to go back, if it is, Carlos, we can just skip it. But the next video shows one of Japan's many nuclear power plants. About 30% of Japan's power was dependent upon nuclear power at this
Can you
time.
see the video?
And if it's there, really just what I want people to see is the extraordinary moment of explosion of a nuclear power plant. So, and we can go back to the PowerPoint now.
Oh, are you guys?
Yeah.
Video?
Did everybody, can people see that?
Yes, we can.
Yeah, okay. So the first question I think that one asks about this is whether or not, and Carlos, you can go back to the PowerPoint. I think everybody gets the idea. Is this 3 disasters or is this 1 disaster, right? If we're the government or we're the power plant or we're somebody in a position of authority to think about compensable harms here, do we think about this as compensating individuals harmed by some combination of the earthquake, the tsunami, and the nuclear disaster? Or do we think about it as 3 individual disasters? And there's victims from the earthquake, there's victims from the tsunami, and there's victims from the nuclear meltdown. The government had a relatively easy time making that decision. Why? Because there is no real compensation system in place for those who were harmed as a consequence of earthquakes or tidal waves. And I think unlike something Carlos said about Brazil, which is Brazil has relatively little experience dealing with disasters. 40% of the world's disasters occur in Asia, and 90% of people who are victims of disasters are in Asia. So Asia in general, and in Japan in particular, has a tremendous amount of experience dealing with disasters. And the fact is, for this disaster, the focus for compensation, the place where law and the courts have really come in, has been with regard to those who were harmed as a consequence of the nuclear accident. Japan, like every country with nuclear power, struck a grand bargain between the government and the population, where nuclear power was seen as a critical source of powering the country and the economy, but it was also appreciated as carrying a relatively small risk, but tremendous consequences, tremendous harms in the event of an accident. There are several international conventions that deal with nuclear harms: the Paris Accord, the Brussels Accord. The United States has the Price-Anderson Act. Japan has the Nuclear Damage Compensation Act, which basically says to local communities, we want to put a nuclear power plant in your community. If there's an accident, you will be compensated without having to show that anybody was at fault. You'll be compensated under a no-fault basis. And to show you that we're serious, that we really mean it, we're going to require the nuclear power company to set aside a large sum of money so that if there's an accident, they'll have this bank account basically full of cash that they can dispense. And the amount of money that the company was forced to put aside, here it was the Tokyo Electric Power Company, TEPCO, was 120 billion yen, which is a little bit over $1 billion, which was in line with the amount of money that nuclear power companies globally had to set aside under the Paris and Brussels Accords. Now, nuclear power companies can get out of paying anything if the nuclear accident is the result, and you can see the last phrase there, of a grave natural disaster. In the event of a grave natural disaster that triggers a nuclear accident, the government is responsible, not the power company. So it's interesting that it's the government that gets to decide whether there's a grave natural disaster or not. And it'll probably not surprise you that the Japanese government decided that despite a 40-meter tsunami and a 9.0 magnitude earthquake, this was not a grave natural disaster. And TEPCO would therefore be responsible. So you can click forward a little bit, right? This is just the definition of a grave natural disaster. What happens if 120 billion yen isn't enough to cover the damages? The government under the law can step in and cover the gap between what was set aside as an indemnification fund and what the cost actually was. And as you'll see in a couple of minutes, the gap was enormous. A difference between 120 billion yen and over 9 trillion yen of actual payouts. How does the compensation get paid, right? I know the focus of today, at least from my understanding on the poster, was really to think about a range of non-court approaches, right? How do we get, as Carlos said, how do we get the money to the victims quickly? Because time is always of the essence for disaster victims, or for personal injury victims, but particularly for disaster victims who may have just lost their homes and lost their loved ones. They need money quickly to start rebuilding their lives, and going to court is almost never quick. So there are 3 ways, if you're a victim of this disaster, that you can seek money. You can go directly, and these are ways that are sketched out, I should say, under the Nuclear Damage Compensation Act. They weren't invented at the last minute as a consequence of this accident. There's what's called the direct route in Japan. You can go directly to the Tokyo Electric Power Company and the government with a kind of a petition, a form that you fill out with your name and address, and a document that suggests what kinds of losses you claim to have suffered and what compensation you think therefore would be appropriate. There's then what's called alternative dispute resolution. Now note the language. I would call the direct route going to TEPCO alternative, right? It's an alternative to the courts. Litigation is the standard way we have in our societies for people who are harmed to seek compensation. So I'd say that Japan has 2 alternatives and 1 conventional approach. Conventional is litigation. Alternative 1 is the direct route to the Tokyo Electric Power Company. And alternative 2 is what was called ADR. And ADR involves another form of compensation under the Nuclear Damage Compensation Act for those sorts of claims that aren't easily handled under the direct route, the kinds of plaintiffs who may be unusual, or the sorts of losses that may be unusual. Can you flip to the next one? If you're a victim of earthquake and flood,
Caio, I think he froze, didn't he?
I froze.
Brazilian compensation standards are like, but under US or Japanese compensation standards, $50,000 for the death of the primary breadwinner in a family, 5 million yen is very, very little money. significantly less in most cases than a person's single annual salary would be, and 2.5 million yen for the death of others. So if you go to the next slide, you'll see that if you think about, I think it's the next slide. Yeah, you may have to hit the arrow a few times. There you go. If you think of that as that big red circle as the entire amount of money being dispersed under the various compensation schemes for victims of the Fukushima accident, the amount of those of money that went to those who suffered injury as a consequence or suffered loss as a consequence of the earthquake and tsunami as opposed to the nuclear accident is really quite small. We can go to the next one. So what is it that constitutes a compensable harm, right? What sorts of things can those who are harmed by the nuclear explosion seek? Remember, almost nobody was killed as a consequence of the nuclear explosion, right? All the deaths, all of the destroyed homes and automobiles and such, that was all the tsunami and the earthquake. So the people who suffered from the nuclear harm were largely people who were evacuated from their homes, right? They were told that the level of radiation was unsafe for them to stay at home, or they weren't forced to evacuate, but they chose to evacuate. Remember, evacuation line goes, it may go down 43rd Street, which means everything from 43rd, 42nd, 41st down is evacuated, but 44th Street and 45th Street's not evacuated. Now, the people living on 45th Street with 3 children see their neighbors required to be evacuated, but they're told they don't have to evacuate. There's a pretty good chance they're getting out of there. And so people suffered because they were forced to leave. People suffered because they chose to leave. People lost their businesses, they lost their incomes, but there was a huge fight as to what counts as a compensable harm. Can you go to the next one? One example of that, and I think you could probably hit a bunch there, right? So here's a list of the sorts of things that were compensable. Oops, sorry. Right, evacuation expenses, physical harm, pain and suffering, lost or decreased property value. What's your house worth now that the area has been horrifically subject to high levels of radiation? Damage of business, lost income, and then decontamination costs. You can go to the next. One of the really interesting issues, and these are, I'm going to try to just jump these. This image is of we have an expression in English of the fox guarding the hen house, right? The fox is the one who wants to eat and kill the hens. And so it's never a good idea to put the fox in charge of the hens. But putting TEPCO in charge of compensation when TEPCO's got to pay the money out for compensation was not necessarily an idea that suited the interests of the injured very much. And so the initial form that people had to fill out was something like 70 pages with extraordinary detail, which was not easy for people who had just been evacuated, traumatized, and living in shelters. Oh, sorry, I have a dog scratching at the door behind me, but I'm just going to ignore her. So you can go to the next one. The compensation for mental distress, emotional distress, was a hugely contentious issue, right? Many people suffered no personal injury. Their homes were intact. They weren't knocked down. They were just in dangerous areas. But people were worried. Were they exposed to high enough doses of radiation that they were going to get cancer? Were their kids harmed? Was it going to affect them cognitively, et cetera? Now, under US tort law, it's extraordinarily difficult to collect for freestanding emotional distress, almost impossible. It's not hard to collect for pain and suffering if you've suffered physical harm. But if you haven't suffered physical harm, collecting for emotional harm is quite difficult. Under Japanese law, it's not. And freestanding emotional distress claims are quite common. And the majority of money that's been paid out has been for freestanding emotional distress. And in many cases, people were being paid somewhere between $1,000 US and $1,500 US every month for many, many years to compensate them for their emotional distress. But there were distinctions made between the emotional distress, for example, suffered by somebody who was required to evacuate, as opposed to the emotional distress of those who voluntarily evacuated. And those sorts of issues have become quite contentious. Can you go forward? I don't remember how many slides I have left. So you can go through that one as well. I don't want to take time on that. You can see here, I mentioned that TEPCO was required by the Japanese government to set aside 120 billion yen in the event of an accident. And you can see here, and this is as of January 29th, 2021. So just a couple of months ago, TEPCO had paid out almost, right? This is 9,600 plus billion yen. So 9 trillion yen really paid, as opposed to 120 billion yen set aside. TEPCO has fundamentally been nationalized. The government has paid out the vast majority of this money because TEPCO didn't have it. And the situation that we face globally is exactly like this situation, where the owners and operators of nuclear power plants can largely externalize the costs of accidents by relying on the government. And the government sees that as appropriate because it sees energy and power as a public good, and therefore is willing to strike this bargain. You can skip that one as well, Carlos. Thanks. Thank you for doing this. There's all sorts of legal maneuverings around what counts as being able to move back to your home and for how long the government will continue to pay your rent for you when you're in temporary housing. You can skip forward again. And all of those issues were issues that were brought directly to TEPCO. TEPCO appointed a committee under the Nuclear Damage Compensation Act to decide what sorts of harms would be compensable and what the appropriate compensation amounts would be. The committee was heavily loaded towards lawyers. One of the senior most members of that committee was former Waseda University President Kamata, who had been dean of the law school and is considered the leading thinker in Japanese civil law. And what they did, not surprisingly, was develop a set of compensation standards that looked a lot like Japanese tort law, but applied in a setting outside of the courts. Those exact legal standards were applied by the mediators under the alternative dispute resolution approach. The mediators applied those, but then articulated some general principles that would enable them to shape their strategy for providing compensation. A relatively small number of claims, as you can see, 24,000, 25,000 claims have been handled under ADR, far less money paid out. I think for the people who are injured in Japan, their hope was to bring aggregated claims under ADR, the equivalent of a class ADR action, where they would aggregate thousands of plaintiffs and seek a resolution through the ADR system. And the ADR system, or those who ran the ADR system, decided at some point that they were unwilling to entertain aggregated claims and that individual claimants would have to bring their claims. And so what was seen by sort of cause lawyers and plaintiffs groups or complainants groups as the greatest possibility that was being offered by ADR was largely destroyed by I don't want to say an arbitrary decision, but by a discretionary decision by the mediators under the ADR system, all of whom, by the way, were lawyers. There were just under 300 lawyers altogether working on the ADR system. in addition to which the compensation through the ADR system was seen to be somewhat lower than that brought through the other system. Okay, the very last thing, and I don't want to spend a lot of time on it, but as you can imagine, there's all sorts of litigation here. There's been litigation against General Electric, which manufactured a good deal of the equipment in the plant. The Japanese government does not enjoy sovereign immunity, so there's been a great deal of litigation against the government and TEPCO. Some of it has been by those who voluntarily evacuated, challenging that distinction. Some of it has been by those who feel like the government and TEPCO were at fault. They don't want to go through a system that says fault isn't relevant, right? The Nuclear Damage Compensation Act is a no-fault system, but many of those injured have said, we want those who are responsible for this to take responsibility. We don't only want their money, we want an acknowledgement that they have acted poorly and inappropriately. And so there's quite a few cases in that way. There's litigation against senior executives at TEPCO, criminal liability for negligence, for failing to appreciate the likelihood of a large nuclear accident and guard against it, etc. The lawsuits have been modestly unsuccessful, I would say. A few have come through for groups of plaintiffs, and many of these are aggregated lawsuits. Most of them are still pending or are on appeal. So I think, for me at least, far too early to say whether litigation will turn out to be an effective strategy for those who were harmed. Right, and so here I just list, they want an apology, they want compensation, and they want community. Yeah, you can keep going, Carlos, thanks, because I want to wrap up. Here's some of the barriers, I think, obvious to all of us as lawyers. Causation here is incredibly complicated, hard to know exactly who the appropriate defendant is or what the nature of their duty is, and measuring damages is really tough. So I think there's one more. I guess the conclusion here on the left slide, these are pictures of exactly the same street, one immediately after the disaster and the other several years after the disaster. And I guess the question I think one of the questions we want to ask ourselves here, and you can hit the arrow once, is whether this was a total failure, whether we're left here with the aftermath of ruin and a broken legal response to this, or whether it's been a remarkable success. 9 trillion yen paid out, tens of thousands of claims brought, areas reconstructed. I think most people looking at the Fukushima issue would say it's better described as a failure than a success. And so I just want to push back a little bit to suggest that the payment of 9 trillion yen in a relatively short amount of time, most of that money was paid out within the first couple of years, is an extraordinary accomplishment, even though the majority of people who suffered significant personal injury or property damage got nothing at all. So I want to end there and thank all of you and apologize for the technical glitches here, but I'm glad we got through it, and I'd love to engage with Carlos and everybody else on the call.
Many thanks. Well, thanks a lot, Professor Eric, for the presentation. It was very complete. And I also found very interesting that you brought up the relation between this assumption of risk and how it interacts with the public interest of the use of nuclear energy in a high-risk country. Also, also the response provided by TEPCO and the Japanese government to all those stakeholders. Perhaps, I don't know, perhaps Professor Carlos and Professor Eric would like to present their questions to one another before I bring in the questions from the spectators. If not, I can bring them immediately, but perhaps you have insights
So-
to share.
Eric, considering that you also wrote about it, I think looking from far away at the first glance, I also identified the Fukushima response to be a success in the sense, at least compared to what we saw in Mariana, and the reference on how to deal with disasters like that in the future in Brazil. And since the Japanese society is traditionally understood as being a society that is very exposed to natural disasters, so as a result, a large part of the population actually has insurance and disaster insurance and home insurance, car insurance, everything insurance. How important was that in the recovery process in general? And also, I know that you discussed this issue of also having a mandatory insurance system. How would that have helped the process to eventually be even more successful than the process that you described, and eventually reduce this feeling that, you know, a lot was done, but eventually not enough, or not as much as people would like to have gotten done?
Yeah, well, that's a really great and really hard question to answer in a short time, but let me do my best. The communities in northern Japan and the Fukushima prefecture in that area tend to be communities that are relatively poor and relatively old. Many of them are dying communities. The young people have left and have moved to the cities. That means many people, I think less than 20% of people up there, I think, had earthquake insurance. And then, of course, once their community is destroyed, and it's taking a long time to move back, there are many communities where the relative number of people who have come back is extraordinarily small. So, you know, I think you're absolutely right. Insurance helps for those who are able to use that money to somehow recreate a life. But for many of the old couples there, long retired or close to retirement, owning a single fishing boat, having a small home near the coast, the kind of insurance they had generally was inadequate to allow them to do much of anything. And I think the loss they suffered, and I wanted to recommend, I'm sure you know it, Carlos, but I don't know if your students do, a book called The Buffalo Creek Disaster by a Yale sociologist named Kai Erikson, whose father was one of the most famous psychologists of the 20th century, Erik Erikson. And Kai Erikson's book about the Buffalo Creek disaster, I think, is relevant to Brazil because it involves a broken dam and a flood. But it also talks about trauma as one of the greatest harms caused by a disaster. It's the loss of community more than the loss of one's house. It's that your neighbors are no longer your neighbors. Your local store is no longer there anymore. And the communities in Fukushima were of the age where there was no rebuilding. There was no recovery possible of the communities that they lost. And in some sense, this makes these kinds of losses non-compensable, right? Because no amount of money will bring back to these sorts of individuals the kinds of things they've lost. There's been very little talk in Japan about sort of new structures for mandatory insurance or anything else for victims of earthquakes and tsunami. It's I think very much the sentiment that the government would be out of business and out of money if it compensated all victims of natural disasters, because there's so many of them. There was a bunch of tornadoes a couple of days ago and thousands of people lost their homes. And if they didn't have tornado insurance, they're in trouble. The other thing I was going to recommend to your students was looking at the Johnstown flood of the early 20th century. This was also a broken dam in Pennsylvania that washed away communities and cost many, many, many lives. And those who were responsible for it, who were the elite of East Coast society at that point, largely evaded responsibility for any of the harms that were caused. I think it's typical in all countries around the world that disaster victims were in many cases already victims in their societies. They were already people who were to some degree marginalized, who were lower income and had fewer opportunities. And so they lived in places that were more prone to disasters. And I think as a social justice issue, that's one of the big things we need to be worrying about in both of our societies.
Yeah. Yeah, I think that's one of the reasons why I thought that in Minas Gerais, at least, only this kind of mandatory insurance could provide kind of quick response that we have, because it's a region that is exactly like this. You have a very, very poor community in those areas around those rivers, and they are all exposed. When I did the research, there were like about 400 dams that were under risk in the region. So it's a very, very large number.
Yeah, I mean, that raises the complicated insurance question, because the same in Japan, right? The nuclear power plants are built on fault lines next to water. So if you and I are running the insurance company, I think we're not going to be very generous when setting the premiums, because the potential payouts are going to bankrupt our companies. And it sounds like it's the same in Brazil.
Yeah. Yeah. And it's an enormous business in Brazil. And one of the issues is that it's fully focused, while most of the mining activity in Brazil is focused on one single state, and all the municipalities around are dependent on the royalties paid by the mining companies. And the government of the state itself is very dependent on that. And, you know, even our balance of payments is dependent on those companies. So in a sense, there is a similar relationship to what you described in Japan, that in the case of Japan needs the energy. In the case of Brazil, we need the mining activity for the taxes that are paid based on that, and also for the entire financial effect that it has. You know, if we reduce our mining activity, our currency will be devaluated. You know, there will be inflation. There's like several macroeconomic effects derived from that. And sometimes it's a sad thing, but we are all part of those disasters in a sense. We all benefit from the lack of mechanisms to internalize those externalities. And that's why, in a sense, I believe that we should think of means to avoid those accidents, or create incentives to avoid those accidents. But it's really hard. I remember that when I wrote that short piece, that I proposed and even talked to some members of Congress about, you know, passing some kind of legislation that would provide at least a framework on how to deal with these disasters. But the response was no, nothing, zero.
Caio, should we give others a chance to pitch in for a few minutes?
Sure. I already have some questions here. So at first, we have some questions concerning social environment insurances. So they are generally related to the extension of those insurances. So if they could be used in regards to the responsibility of financial institutions, which could be related to the disasters, and also how the international statutes concerning these environmental questions is also related to insurances deals with this question. And I also have a personal question. So I don't know about the United States or Japan, but in Brazil, we are seeing some discussion on bills concerning the compensation related to deaths that occurred due to the COVID-19 pandemic. So in the state of São Paulo, we have a bill which is related to the death of teachers that teach in our public school system, and also related to the compensation to their relatives. So just picking this case as an example, I'd like to know if you have some kind of panorama concerning the compensation of victims related to the COVID-19 pandemic, perhaps also related to collateral effects of some treatments employed, and also to problems related to the vaccines. But in the case of vaccines, the case are really small, and I'm not sure if they would apply.
Carlos, do you want to say something about the insurance issue before I jump in?
Yeah, that's a good division of labor. You're a specialist on health law, so I think you're going to do a better job with the vaccine question. But regarding the damages for environmental issues and the compensation for those damages, I think one interesting thing is that the Brazilian environmental legislation provides for the liability of what we call indirect polluters. So indirect polluters is a concept that is not actually defined in the law itself, and case law has not provided a very clear understanding of what this concept might be. In a few cases, our federal Superior Court of Justice, our third level of the legal system in Brazil, we have that above what would be your federal circuit. We have a national federal circuit. It's this Superior Court of Justice. And this court has provided some basic guidance, and it indicated that banks, basically financial institutions that finance polluters, can be held responsible. So that is something that the Brazilian banks have been taking very seriously, because some of them can go bankrupt on a situation like that. So one helpful thing that happened in the last few years is that those large financial institutions, they have become much more careful in financing companies in the in the primary sector, basically agriculture and mining and all kind of natural extraction activities. But in a sense, that helped with the mining companies. So some of them have been changing their policies. We have been seeing some of the mining companies really by themselves determining the removal of communities from areas that have been exposed for dams that might break as well. But especially in the agricultural sector, that is more prone to smaller environmental disasters. What we saw is something that might be a bit dangerous, in a sense that those large financial institutions, big banks that we know, the 5 big banks, they stopped providing finance for many of those companies in the agricultural sector. And those were covered by these cooperatives most of the time. And those cooperatives, they have been growing in Brazil a lot in the last 5 years, basically. They became huge. Some of them, you just learned that they existed, you know, a few days ago, and they started making advertisements on national TV. But they became very big, but they don't have the same expertise of the large banks on evaluating environmental risks. So in a sense, some things have improved. In the other sense, the results that were a result of market movements might increase some risks of environmental disasters in the future. So that's when, you know, governmental regulation needs to step in and provide a system that might stimulate a more coordinated action between regulators and the private sector. And that's when the mandatory insurance, I believe, could provide a good result. Sometimes you could have mandatory insurance that is not complete, let's say, that will not cover all the damages and will not lead to what Eric presented as one of the problems of this system, of having like such a huge premium that nobody would be able to pay for that premium. So what you would need to do is by law, you would have to regulate what could be done, basically. So what you could do is to limit the payments that the insurance companies would have to pay to individuals. So it would provide them, you know, with some little cash that they could, you know, basically rebuild their house or something very quickly, but would not compensate all the damages that they would suffer. You could take away, for example, any pain, suffering damages and focus on, you know, the houses or things that are just basic. So you could limit the extent to which this mandatory insurance would work. So I think that you could, for example, take all the environmental damage out of it and just focus on the people that would suffer the damages, and that would make that system feasible.
So let me add just quickly on the COVID situation. I don't think there's much chance of general approaches to compensation for those who have been affected by COVID. I think there's way too many victims for most countries to handle. So my sense is that in most cases, they're going to have to fall back on more standard forms of litigation, medical malpractice, for example. A lot of the cases we're seeing in the US involve a workplace. We've had lots of cases of, for example, people in meatpacking plants and other sorts of factories being disproportionately affected by COVID. But in the US, they're unable to litigate because they're covered by workers' compensation, and workers' compensation prohibits workers from suing their employers. So the cases we're seeing are kind of like the asbestos take-home cases. It's not the worker who's suing, it's somebody in the worker's family. And the claim is that I am the spouse of an employee and I was infected with COVID by your employee as a consequence of your negligence, and therefore I have a claim against you that my spouse can't have because of workers' comp. Those are very, very difficult cases because causality is quite hard in them. So Caio, I think you're right. We're going to see all sorts of different efforts at litigation around COVID. My sense is it's not going to be treated as the kind of general compensation approach that we've been talking about. I see there's a couple of questions, Caio, and so shall we? I know our appointed end time was a few minutes ago already, but maybe we can go for just another 3 or 4 minutes and at least hear some of the questions from the students, but you're the boss, so you tell me.
Sure. If some students would like to make some quick questions to Professor Eric and Professor Carlos, feel free to do so. I believe there's a raising hand function, but I can't find them here in my screen.
Nina, Mila, Danielle, and Felix raise their hands. I can't see the
Yeah, why don't those of you with your hands raised maybe just unmute and you can ask your questions and we'll see whether we can answer them.
I may start.
Okay, you can start.
Thank you. Good evening, first of all, and thank you for Professor Portugal, Professor Feldman for this most thoughtful presentation. My question is, in both cases, in Mariana and in Fukushima, we talk about civilians or companies, but my question is, when is a state that is affected by the disaster? We can talk about Insurance International Fund linked to the UN. I think in more pragmatic way, when talk about the hydropower electric plant that is built by Ethiopia that could cause problems in the Nile for South Sudan and Egypt. So if that is a possibility for an international insurance fund when talking about different countries that can be affected. Thank you.
I think the quick answer from Japan is that some of the Japanese plaintiffs tried that. I think what would connect with your question, and it's a really thoughtful one, would be, for example, the effort to sue General Electric for its negligence and having built and sold a set of reactors that couldn't withstand the sorts of problems they ran into in Fukushima. The problem there was because we were dealing with the Nuclear Damage Compensation Act. The court was very focused on the necessity of claims being brought on a no-fault basis against TEPCO and the government, and didn't think GE was the appropriate defendant there. So, and you know, I guess the other piece of it on the substance is it would have been extraordinarily hard, I think, given that those same reactors were used in nuclear power plants around the world, for the plaintiffs to succeed on the merits. You dig in, you end up in extraordinarily technical terrain really quite quickly there, and finding the correct expertise from the nuclear industry to testify against GE, I think was going to present a range of problems. But you're right, it's an issue across a lot of these issues where we have large multinational corporations with fingerprints all around the globe.
You know, as Eric mentioned, we don't have an international organization that is, you know, responsible for the consequences of natural disasters or environmental disasters. And that's a real issue for the world. I know that the largest insurance companies, they're very concerned with the increase in the number of natural disasters due to the climate change. And, you know, surprisingly, those insurance companies are really pushing governments all around the world to implement policies and think about a global system to deal with disasters. But, you know, the lobbying of the insurance companies is not enough to contradict the lobbying of the energy sector and so many other sectors that might be affected by any policy in this sense. Let's see, you know, with the change in the US government, eventually something might change as well. But, you know, I don't know if Eric is aware of it, but I haven't seen any major initiative or proposal for creating under the UN or any other multilateral organization any meaningful mechanisms to deal with the natural disasters that we will certainly see in the next few years. But it's certainly something that is needed, and another topic of research if you guys want to follow.
Thank you.
Thank you. We are sometime we went over the time limit for some minutes. I think we can hear Mila's question, and then the students could send us the questions, and then we can email them to the professors. I believe this way would be fine, and we can. And sorry once again for our time, Professor Feldman and Professor Carlos. So, Mila, please go on.
Hi, good evening. I'll be quickly. My question is, if it's so hard to recognize the damages caused by Fukushima case or the Brumadinho case, how would you apply this insurance? How would you recognize the need for insurance by, for example, the construction of Usina de Belo Monte and the construction of nuclear station that would force people to leave their communities and would force the flood of environment, and it would cause several environment damages, but it wouldn't be recognized as a natural disaster. I don't think it would be considered as these natural disasters, but it would be also a disaster with a lot of victims. I don't know if it makes sense.
Yeah, look, I think there are some damages that are really easy here, right? So, and I think as Carlos was saying before, so one could easily imagine insurance that would cover personal injury and death as a consequence of the earthquake or tsunami or nuclear damage. One could easily imagine insurance that would cover the loss of one's home or damage to one's home and other sorts of property damage. We saw fishing boats getting destroyed and automobiles getting destroyed. I think lost income is a typical expense here, and where people have lost their fishing boats, they've also lost their income from fishing, or when the town is destroyed and the port is destroyed and the water is polluted, you have lost income. What you don't have much in Japan that we have a lot in the United States is medical expenses. Medical expenses are extremely expensive in the US and a significant part of damage awards. But because there's national health insurance in Japan, people's medical needs are mostly met without having to embed them in insurance, though they have a copay. And so one could imagine that the insurance would cover all of those costs beyond what their standard health insurance would cost. Maybe medical care for mental health, for the emotional distress that people are receiving. Mental health care in Japan is not a terribly refined or common kind of medical treatment, but I think after the sort of trauma that people sometimes experience in disasters, that sort of care becomes highly valued. But you're right, there's no way of insuring against the loss of one's sense of community, one sense of purpose, one sense of what counts as home, and one sense of where he or she belongs in the world. Those aren't insurable losses under any form of tort system that I know. But there are surely some concrete sorts of losses there. I think the question is going to be whether we can find insurance companies to price that kind of insurance in a way that's affordable. I'm in California right now looking out my window in a high rise in San Francisco, and lots of people don't have earthquake insurance here because it's so expensive, and they're willing to just self-insure and take the risk.
Yeah. And Mila, in the case of Brazil, you touched in a very good point that one of the reasons why we were not able to deal with the disaster situation is because we also did a very poor job with all the communities that were moved from as a result of dams that were constructed in Brazil for 40, 50 years, especially after the military dictatorship. So Eric, in Brazil, the main energy source is electric power plants, and we have those kind of dams all around, and poor communities were moved all over Brazil because of those dams. And we have a horrible history of how we treated these people. In Minas Gerais, even you have several cases that the results were just tragic and for pure stupidity. Like in certain cases, you had rural communities that were moved and people built like those like fake cities, ghost cities for these people. And 2-3 years later, you had very high levels of depression in these communities because you took some people who were supposedly extremely poor that lived in from agricultural subsistence in very poor, apparently poor areas, and then you have these electrical companies that think, well, it's a great idea to build a city for these people, so I will give them running water, electricity, and they will be very happy watching TV. But they get depressed because they used to have, a chicken where they can get eggs, and they could have a small plantation for their basic needs. And they were apparently poor, but actually they had a better quality of life. So they would be much wiser if they had just bought plots of land, eventually larger plots of land than these people had before, and just given them those small farms, and they would be much happier. So eventually they spend even more money building these artificial towns for these people, but that's not what they needed. So sometimes it's just stupidity, it's the lack of knowledge or of know-how, how to eventually use this opportunity to even improve the lives of these people instead of worsening the life of these people. If we had taught better how to do that in the past, if the public organizations that were responsible for mediating this process were more thoughtful, eventually we would have more experience of how to do that, even all natural disasters. But you're right, that's a problem that we need to learn how to. And in this case, insurance cannot help because it's not an event, unforeseeable event is something that just happens, but there is a connection between those processes, certainly.
Thank you.
So thank you once again, Professor Eric Feldman and Professor Carlos Portugal Gouvêa, for joining us today. It was a very nice discussion with very relevant topics in both scenarios, and I invite you to join us once again in the future.
Thank you.
So,
Really
thank you,
great to
Caio.
be here. Pleasure to see everybody. Thank you for making it possible and inviting me.
No, thank you, Eric. It was wonderful. Thank you so much.
Thanks. Thanks to you, Carlos, for being the leader of this.
It's a pleasure to have you here again, and thank you so much for helping us over this year since we started CELA here in São Paulo.
Thanks.
Hope to see
Have a
you
nice
soon.
evening.
Bye-bye. Thank you, everybody.